rebuttal?
Yeah, let's go 12 and 3.
Okay. All right. Oh, and I guess I didn't introduce our panel. I'm Judge Angela Coble, and sitting with me today are Judge Isherwood and Judge Hurst. And thank you guys for being, working with us to get this reset. Probably not what everybody wants to do on Friday afternoon, but here we are. So thank you for being flexible and getting this scheduled. Okay, well, we'll go ahead and get started then. I'll turn it over to you, Mr. Crabtree.
May it please the court. I'm grateful to be arguing in front of you today. I think this is a really important issue. Voir dire is very important. It's a critical aspect of trial. More than one attorney and judge has told me that cases are won and lost in voir dire. I don't know that that's always true, but I think that's sometimes true. In this case, the court required us to not only do a town hall style voir dire that was an experimental process over the objection of both of the attorneys, but instructed us to work together at the same time in front of the jury. I believe that that decision by the court was an abuse of discretion and unfairly prejudiced my client's rights to a fair trial. The reason the court gave initially for requiring this experimental town hall style voir dire is that traditional voir dire bores the court. The court did go on to say that he thought it's important for the attorneys to show the potential jurors that they're working together and they're congenial. Here's the problem. It is inherently unfair to the plaintiff to have to do voir dire at the same time as the defendant. We are in an adversarial system. We don't pick the 12 best jurors. What my job is to find the jurors that have bias and prejudice against my client or for the other party's client, and then to identify them and either strike them for cause or be able to use a peremptory challenge on them. The defense's job, if he or she does it right, is to do the same. And if the judge does their job right and the defense does their job right and I do my job right, then hopefully we end up with a fair jury. But we have completely different aims and objectives within the voir dire process. So just by its nature, we're going to move from one topic to another to another. And I don't believe that gives me the opportunity that I need to fully and completely root out hidden bias and prejudice in the potential jurors. And I do believe that in Johnson County, Kansas, when I'm trying a med mal case, there is hidden bias and prejudice that people have sometimes that they don't recognize themselves.
Mr. Crabtree, can you help me understand, and just to be clear, are you Mr. Crabtree Sr.?
Yeah, and I apologize. So there are two James Crabtrees. One goes by Jamie. I go by James. He is the younger one is James S. Crabtree. I am James M. Crabtree.
No problem. I just wanted to clarify for my notes which Mr. Crabtree we were speaking with.
So Jamie or James S. Crabtree was on the briefs and provided most of the briefing, and then I was lead counsel at trial, and he assisted me in second chair.
Can you help me understand why this style of voir dire is more prejudicial to your side than to the other side? Because it seems like you both, I understand both parties objected to it to the district court and
Sure.
Nobody wanted to do it. But I don't think I quite understand why it's worse for you.
Right. I think that's a great question, and I appreciate that. The short answer is because I have the burden of proof. The other answer is instructive by what happened in this case. And really that comes down to, besides being disjointed and being unable to follow up one question to the next, what defense counsel asks and the questions they ask affect the responses of the juries and their impressions of the next questions. Let me talk for a minute specifically about this case. In this case, Mr. Lynch took the first substantive question. I didn't know what question he was going to ask. I didn't know that he was going to take the first substantive question. And the question he asked was a question that is, in my view, completely irrelevant to my case. My case was about surgeries that did need to happen and cosmetic damage that occurred and resulting in a deformed breast and the need for cosmetic surgeries to correct that. That's my case. The surgeries happened as a result of a stage 1 cancer. Nothing about my case dealt with cancer or alleged that the negligence had any causation to any additional cancer. But the first question Mr. Lynch asked was for everyone to identify who had cancer or had family members or close friends with cancer. And then after identifying about 14 of those people, he then went through and did about a 20-minute or 25-minute questions. And I apologize, I don't know the time exactly. It seemed like forever, on their feelings about cancer and whether or not they could be fair with cancer and what the outcomes were of their families. And it was dramatic, and there were tears that came out at times during this. And then after the second person, he turned to me and said, "Mr. Crabtree, would you like to take the next one?" And I was faced with a decision. Do I stand up and do this voir dire that is not got anything to do with my case? Or do I sit on my thumbs for an hour and a half and let him do it and not be a presence in front of the jury? Or do I stand up and say, this isn't really relevant to my case, and I'd like to ask this? Could I have done that? I don't know. There were no rules. I didn't know what the rules were because this was an experimental procedure. So the choice I made, and I'm very aware when I try a medical malpractice case from voir dire that my credibility is important. And if I get up and I'm obstructive, that's a problem. And I was afraid that if I got up and said, "This isn't really relevant to my case, I think we should talk about this," the judge was going to get on me in front of the jury. So I chose to take part in this process. The process took about an hour and a half. So normally, if it was my voir dire, what I would have covered was how the jury felt about unnecessary surgeries, who had cosmetic surgeries or had close friends that had cosmetic surgeries. How would that affect them? Those questions are really good questions. And we would have gotten to some really good answers. And one of them being the person who was struck 4 days later, who never really talked about the cosmetic surgery portions because she brought it up in relation to a question about her feelings about cancer rather than her feelings about cosmetic surgery. So that is one example of how the disjointed process didn't allow us to get to information that was critical. And I suspect if we had gotten to that juror that ultimately was struck, we would have vetted her. And I don't think there was anything that she would have said that would have disqualified her from jury service. But we would have been able to get to that issue during voir dire when it should be taken care of. But then we get done with that issue, hour and a half, long time. And I have to decide where to go next. And the jury hears the question about how they feel about cosmetic surgeries very differently after talking about horrible results in cancer for the last hour and a half than they would if I brought it up in the first place. And so I think that's a really good example of how having a separate voir dire is important for the plaintiff, important to be able to get to what potential jurors' feelings are and to fully vet those people. There was
So
another.
Mr. Crabtree, if I could interrupt you for just a moment. So is it your position that this is never a reasonable way to conduct voir dire, that under no circumstances? It would
Yeah,
be-
thank you, Judge. I appreciate that. And I'm not a big believer in always and nevers at all, but I think that if neither party objects and they want to attempt to do this type of town hall style, I think that's fine. They know what they're getting into. I think there maybe are certain cases with simpler issues where it would be appropriate to do that. In this case, where you have a complicated medical malpractice case, either party that lost this case would have been up here with this appeal. And because it's not an appropriate forum to use for this type of case. So I think the court has a choice about how they would want to rule that it is unfair, whether it's unfair in all cases or just this case, if that sort of gets to the decision that you have. I do think that it has a very high likelihood of not being fair and not being a fair process. I think it has much higher likelihood than the traditional voir dire process we have.
When you're using fair, I'm sorry, Judge.
Sorry, I was just gonna say, is fair, is this suspicion though? Is that enough to overcome the discretion? I mean, the district court has wide discretion on how they're handling voir dire. So is a suspicion of bias, is that enough?
I think it's more than a suspicion of bias. I know you can't look to the results of the case, but I had a very strong case. I felt great about this case, and I felt like I never got a fair shot from the beginning. I think that throughout the process of voir dire, it was evident that for whatever reason, the court was not able to focus on getting a jury that was fully vetted and fair. I've used the example in my brief of I think she was an anesthesiologist who stated that she had a 8 out of 10 in terms of her dislike of medical malpractice cases, 10 being she could never, ever find for a plaintiff. And in describing that, she said that she would need clear and convincing evidence of negligence and abuse in order to find for a plaintiff. That's enough. That's got to be enough for a strike for cause. That strike for cause was denied. And part of that, we didn't get to that issue that I would normally have covered within an hour and a half until lunchtime. And then we got interrupted before we even made the motion to strike. And we had the whole lunch in between that time. I've given other examples of what she said that I think were inappropriate, even so far as asking her directly, I'll just ask you, are you biased? And she said, yeah, if I'm being honest, I have to say I'm biased against this kind of case. I know Judge Vano, and I think Judge Vano is a good judge, and I don't think he would miss that in normal circumstances. The only thing I can attribute that to is the disjoint nature of this voir dire. And so when it came to me deciding whether to use a peremptory or not, I got to decide whether I want to try to win the case or whether I want to win the appeal on that issue. Because I think if I kick her with a peremptory, most likely I'm not going to be able to overcome the standard on appeal for that. So I used the peremptory on her because I thought we had a very strong case. But I think that those answers, when they're given, and she's not removed from the jury, then end up informing the rest of the jury, well, why should I talk about my little bias, my just sort of dislike of medical malpractice cases, if this woman has just said that she's got a bias and prejudice against them, it's not enough to kick her off the jury. So I don't think I ever was able to get to a clear examination of the bias and prejudice. I do want to talk very briefly about the second part, and I don't know how I'm doing on time.
Yeah, I think you've got about a minute and a half. So
okay, so very briefly on the second part, I feel strongly that this merits a reversal. I think the court brought up in the last argument the Castleberry standard. We didn't brief to the Castleberry standard, but I do think that's the correct standard to use. In this case, Mr. Lynch held up an exhibit that had never been referred to, shown, examined at trial, and made a statement about what that exhibit meant. And it was wrong. It was a statement where he said, this is how it is supposed to look. That's a medical opinion that was never sought out from any expert witness on the panel. So what happened in this case, and I'm not sure if I have enough time to get to this, but the first procedure was done. They put a wire into where a clip has been left during a biopsy. And the wire directs the surgeon where to do the surgery. The surgeon then goes in and takes a clump of tissue out around the clip and around where the wire is and removes it. First time in 30 years, the surgeon takes it out, no cancer, no clip. Clip's still in her body, so he goes to the wrong place. A week later, they go do a second procedure, different procedure. They used a mammogram to place the wire in that procedure. They go in, she was across campus when they did it. Instead of wheeling her directly from the radiologist's office into the operating theater after the second procedure, they actually put her in a van, drive her across campus, move her into room, do the second lumpectomy. They get enough tissue out, they get the cancer out, her breast is then deformed, and the other stuff follows. But the only evidence about any clip that was submitted at trial was about the clip that was used in the first surgery. And Dr. Anderson, who was the surgeon, said, that's about how they look. It's normal. That's not abnormal. So if there was evidence that was brought up about this second picture, Exhibit 16, I would have been able to cross-examine. I would have been able to examine why it is they look different. What is the difference here? So I think that left me at a huge disadvantage that I had no way to respond to. And I do think it was prejudicial. It went directly to the heart of the defense and the heart of plaintiff's case. It was exactly on point. So I think my time is probably up.
Yep.
We'll talk to you in a couple of minutes.
Okay, thank you. And I was pretty liberal with you, Mr. Crabtree, so I'll be the same with you, Ms. Lynch.
Okay, thank you, Your Honor. May it please the court. I will kind of work backwards in response to Mr. Crabtree, and I'll start with issue 2 since he brought up the Castleberry case again, which Judge Coble, you asked me about first time around. I have now had a chance to go back and read that case, and I do agree that if there is error found, then it is the burden of the party benefiting from the error to demonstrate that it was harmless. So I do agree that that's the standard. If there was error found in this case, then it would be our burden. And in which case, my response that I gave last time would be the same, that our proof that it was harmless error would be 2 main things. One is that the entire record of this case, the evidence, the exhibits that actually went back to the jury, as well as the demonstratives they were shown, and the testimony from particularly Dr. Robertson and Dr. Kuckelman, supported the ultimate verdict in this case. And that is the holding in Castleberry, for which they've cited previous cases, but it's reasonable probability that the error affected the outcome of trial in light of the entire record. So, and ultimately in Castleberry, they found that the error was harmless because of the record and because the jury was given the same instruction that the jury in this case was, which is that they are not to take counsel's arguments as evidence if it's not supported by the evidence. So I wanted to touch on Castleberry first on that point. I think it's also important before I move on to issue 1 to point out to the court the actual pieces of evidence that I'm referring to when I say the entire record. Exhibit 16 was not, again, shown to this jury in a vacuum. They had 3 demonstrative exhibits. One was a normal Copans wire kit. So it's actually the same wire that Dr. Robertson would have used in surgery with the needle cannula on it and the wire in its original formation with that unique hook on the end. They were also shown a second Copans wire kit with the wire bent in the formation that it looks, or we propose that it looks in Exhibit 13. They were shown both of those items with multiple witnesses, both up close in front of the jury box as well as on the Elmo projector. So they were able to get a little bit more of a blown up version of that. They were also shown, the normal hook wire going into the breast as well as a bent hook wire coming out of the breast in poster boards, artistic renditions of this surgery. So they had seen that in those demonstratives. They had seen the bent wire that had been talked about a lot in Exhibit 13. And I encourage the court, if you haven't already actually read through the testimony of Dr. Robertson and Dr. Kuckelman, they spend pages, which would equate to minutes, tens of minutes, during trial explaining the uniqueness of this wire, describing the degrees in which it is bent and the degrees that it looks when it becomes unbent, and how that unbending can occur. So the jury had plenty of evidence to consider within the entire record to support this verdict, even if there was error in counsel's statements in closing, which we do not concede that there was error, but for argument's sake, that is what we would put to the court as if we're taking on the burden to show that it was harmless. As to issue one, a couple things. It's true, both parties did object at the final trial conference. I think I discussed this with the court last time. We objected because we, like Mr. Crabtree, were unfamiliar with this format. We had never done it before. We wanted to preserve that objection for the record in the event that the format turned out unfair or just confusing to the point that it wasn't really an effective voir dire. And we do not believe that anymore, having now gone through it for a full day. It is not true, I respectfully disagree with Mr. Crabtree, that had we lost this case, that we would have taken this issue up on appeal. We would not have used the voir dire issue on appeal. We believe that it was a fair process. In regard to the juror JH, I don't remember exactly her specialty, but she was the one who had the rating of 7 or 8 out of 10. We've laid out the timeline of the questioning of her in our brief. I don't need to go over it again with the court, but it was not as disjointed, and the lunch break did not really have as big of a impact on that Mr. Crabtree has posited to the court. And I encourage you to go look back at that timeline, because she was questioned 3 separate times over the course of many, many hours throughout the day. And only on that last time, well after the lunch break, in fact, were issues brought up with her being struck for cause.
Ms. Lynch, can I ask your opinion about whether this style impacts the plaintiff differently than the defendant? Mr. Crabtree brought up some points about the fact that he does carry the burden, and because the questioning started in a manner and then didn't allow him to do what he wanted to do, there is more likely to be prejudice to him in this situation.
Yes, and I, again, respectfully disagree with that position. I think both parties were equally positioned to either have a fair voir dire process or an unfair voir dire process. I don't think that the plaintiff going first in voir dire necessarily is required because they have the burden of proof at trial. The burden of proof at trial is the evidentiary burden of proof, which is why they go first in the presentation of evidence, because there is an imaginary kind of line that they have to cross to meet their prima facie case. And if they don't do that, then it's a directed verdict. They have not proved their prima facie case. That is why they go first in the presentation of evidence. That prima facie case requirement is not the case for voir dire. In voir dire, we're simply trying to find as unbiased jurors as we can. And there's no benefit to one side or the other in going first. And there's certainly no rule in Kansas that says the plaintiff must go first in voir dire in order to preserve this right to, well, because they have the burden of proof with the evidence. And I take a little bit of issue with the idea that Mr. Crabtree didn't have an opportunity to ask questions he wanted to ask or cover the topics that he wanted to cover. There was switching out, as I think he already alluded to, once one attorney finished with the topic, both attorneys then, motion to the other one, go ahead and go next and pick whatever topic, whatever question you want. And one of the examples that Mr. Crabtree mentioned was that he wanted to talk about the juror's experience with cosmetic surgery. That certainly was a topic that actually did come up in the discussion about breast cancer, because many of the jurors or potential jurors that identified either a personal history or a familial history or friends that had breast cancer talked about not only the surgery to remove their cancer, but then maybe, however briefly, the surgery that was done if at all, to reconstruct their breasts. So it's not like that topic wasn't covered at all. That certainly could have been something that Mr. Crabtree drilled down further on if he chose to, and maybe he didn't feel like, I don't know. I can't tell you why he decided not to drill further down on that when other jurors mentioned it, but he certainly did have ample opportunity over an entire day to ask the questions he wanted to ask and cover topics he wanted, maybe just not in the order that he wanted due to the nature of the voir dire process. But I don't see how that is in any way unfair or prejudice to the plaintiff. If that answers your question.
Thank you.
I don't know that I have much else to cover with the court. So if the court doesn't have any other questions, we'll just go ahead and yield my time since I already used 18 minutes of your time first time around.
Yeah, I don't have anything else. Anyone else? Did we, a second, did we lose Judge Isherwood? Oh, she lost her connection, so let's just pause for a second. And we'll let her get back on before you do your rebuttal, Mr. Crabtree. Technology is great when it works. Let's see, she's still having connection difficulties, so we'll give it another little bit before we decide to move ahead.
I've cleared my afternoon, so as long as we need.
Okay, I think she's just having trouble in general, so we'll go ahead. This is being recorded, so she'll have an opportunity to go back and listen to what she might miss. So we'll just go ahead with your rebuttal, Mr. Crabtree.
Thank you. I appreciate it. Ms. Lynch, when she began her argument, says that the jury was not shown Exhibit 15 in a vacuum. And I would argue that's exactly what they were shown Exhibit 16 in. This exhibit had never been shown or mentioned or examined or asked about prior uh, to any witness. And with as much testimony as was about the first wire, if that was something that was something they were going to rely on, that it looked the same, that's the way, that's the way it's supposed to look, that's an expert opinion. And you've got to have expert opinion testimony on that. And I don't believe it's true.
Let's say, Mr. Crabtree, that there was an error in showing that. Can you help us understand why it's prejudicial? Because in reviewing the testimony, I think that's harder for me to see.
Right.
The prejudice from that.
I appreciate that. And that's a great question. So the wire, when the procedure is done, the wire that is placed by the radiologist that we say was negligent is supposed to go to a clip that had been left in. He couldn't visualize that clip. He makes a drawing of where he puts the wire. The drawing he has the wire going to a different place than where the clip is ultimately. When the tissue is taken out, the judge is following the picture and the wire that are in the wrong place, not connected to the clip. So the evidence that the clip was put in the wrong place was strong. The surgeon that did the surgery said, again, this is kind of how they look. And we're looking at spectrum radiographs. The first one they shows a bent clip that the way it's supposed to be. And then they kind of have it stretched out. Nobody knows, but my guess is that they tried to look for the clip in there when they were looking at the tissue, and when they were looking for cancer, they couldn't find the clip. Sure. And so they did it. So that all happened. Nobody ever put up the wire used from the week later procedure that was done with the mammogram guided procedure and had anybody testify about how this is how it's supposed to look. So I think that's critical and goes to the heart of the defense, and it goes to the heart of plaintiff's case. And if the jury believes that that's the way it's supposed to look, and it doesn't look that way, we lose. So, I mean, I think that was a critical issue, and saving it to closing and never getting the opinion that the attorney expressed on the record from an expert witness is error and was prejudicial to my case.
So are you saying that the clip, the kits that the doctors testified about, that there was no testimony that those clips, about how those clips looked?
There was lots of testimony about how the clip was supposed to look that was used in this procedure. The procedure that was done on my client was a different procedure. It was done in a room right next to the operating theater, where she was wheeled from that procedure into the operating room. The procedure that was done a week later was a mammogram guided procedure that was done across campus. She was put in a car, she was moved.
Sure.
So is that the same clip? I don't know if that's the same clip. But the testimony at trial from the surgeon is that the clip that he took out is what the clip typically looks like. There was nothing remarkable about the clip
the clip that he took out the second time.
No, the clip that
first time.
The surgeon that took out the first time, the surgeon that took that out, I know it's confusing and I apologize, said there was nothing remarkable about the appearance of that clip. And all of the testimony in the case was about that clip that was used in the first procedure. The picture that was shown in closing for the first time was a picture from the second procedure. And the allegation was that's the way it's supposed to look. And that's
and your belief is that if the jury looked at the second picture and thought, yes, that's the way it's supposed to look, then that's the ultimate legal conclusion for your loss.
Yeah,
that's the ultimate legal conclusion for the case.
Right. That's the ultimate legal and factual issue that would lead them to believe the defense theory that the clip or the wire in the first procedure had been dislodged or pulled, which
during the procedure.
Right. Which had never happened to the surgeon in 30 years of doing surgery.
Their theory is that during the procedure, that's what caused the wire to look like that, as opposed to its placement making it look like that.
Yeah, you got that. Exactly. Their theory of the defense was that the wire and from the first procedure looked different. And then the allegation they made in the closing argument was that it should have looked like the one they showed for the first time in closing argument. So heart of the defense, heart of the plaintiff's case.
When was the picture first shown? When was Exhibit 16 available to the jury?
It was first shown to the jury during closing argument. It was put into evidence by me when I put the medical records in evidence. But here's the, I mean, if I put an EKG strip into evidence and there's no testimony about it.
I understand.
Yeah.
I understand what the enormity of medical record into evidence and what a jury would focus on and not focus on. Okay.
Yeah. So I think that if the jury had gone back to a jury room and looked at that themselves, I think it's very unlikely to do that. But they could come to that or not come to that conclusion, but there wouldn't be any expert testimony on it, as there was not.
I see. Okay.
Well, we've pretty much exhausted your time plus more.
Thank you. I appreciate the opportunity to argue, and I apologize about the first instance.
Thank you. Well, thank you both for your arguments today. And again, we'll take this case under advisement and we'll issue an opinion, a written opinion, as soon as we can. So thank you all.
Thank you.
Have a good weekend.